If it's Tuesday, a high-stakes court hearing is happening right now on the fate of the Maryland man mistakenly deported to El Salvador, as questions loom over what consequences, if any, the Trump administration will face if it defies the courts. And joining me now to talk about all of this is Robert Tsai. He's a professor of constitutional law at Boston University School of Law. So much to dig into with you, Professor. But let's first start with the case of Kilmar Abrego Garcia. The Trump administration really doesn't appear to be taking steps to facilitate his return, despite what they've said in their court filings. And that's despite what the Supreme Court explicitly told them that they have to do. What happens now? What can this district judge in Maryland do to try and find a path to getting him home?
Great to join you. I think it's incredibly important now in the hearing that's going on and in any subsequent proceedings for the district court judge to make a very clear record of this defiance. I think she's off to a good start in requiring these daily status reports. And it's quite clear in those status reports that the government is absolutely refusing to take any steps to bring this individual home. And instead, we get this last-minute report today saying that if he somehow shows up at a port in the United States, we don't know how that would happen, they're going to take him and they're going to send him to a different country. So there's no question here, I think, that while the government is trying to minimally follow these kinds of requirements, they're not at all following the letter or the spirit of the Supreme Court's unanimous opinion. They're not doing anything to comply with what the court called the proper order to facilitate his return. They are playing games in this regard. So what should be done next? I think in developing that record, what will be very important is to identify who is involved, who is dealing with the government's lawyers and making these decisions, because those are going to be the people who are held in contempt first. And then secondly, that will allow the judge to work her way up the food chain to higher ranking officials and also to escalate the sanctions if the early ones don't work. So I think those will be the important next steps. Yeah, so break that down for us. It wouldn't be that she would necessarily hold Donald Trump in contempt right out of the gate. It would be more these court officials, these lawyers that are specifically working on the case today. What sort of penalty could there be associated with in a contempt charge of one of these lawyers that's working on the case? Well, a judge is supposed to start at a lower point of pain. So fines, she could increase the size of the fines. She could make the fines every day. And then she can, if there's more recalcitrants, expand the number of people who are being fined. Any kind of a criminal sanction or threat of jail is supposed to be a last resort. So this is why the record is so important. So it would build to a point before someone would actually be put in jail as a result of contempt. But how long can this process play itself out for? I understand your point here that she's building a record, that you're starting here to demonstrate just how much the administration is defying the court. How long could this process play itself out? Well, it could be a matter of weeks. It could be longer. I think that the judge has indicated that she doesn't want to be toyed with, and I think this is the right attitude. The Supreme Court acted fairly quickly on the government's previous appeal. And I think that, the Supreme Court's initial mistake was to treat the Trump administration here as if they're acting in good faith and to give them kind of the presumption of regularity. But by now, I think what we're seeing is that they really have no desire to comply with this order unless they're directly told by the Supreme Court itself that this man has to be returned and that existing legal protocols have to be followed. The ones that were already identified in the conversation earlier are all available to the government. They just simply don't want to do anything other than to proceed on the basis of, one person's word against him that's not yet been tested in a court of law. So does the Supreme Court need to be more clear what they're looking for, not give them any wiggle room with their language in the rulings that they hand down? I think 100%. I mean, in a way, what we've seen historically is they sort of are following what the Supreme Court in an earlier period did with the desegregation cases, and to sort of give defendants opportunities to sort of comply and give a lot of flexibility. But here, I think it's a mistake given what the Trump officials have indicated to everybody, including in their filings. So they have to be much more pointed and direct about what they want to have happen and how quickly that must happen. If there's any positive evidence, we really haven't had a president defy a direct opinion by the Supreme Court of the United States. In the Hamdan case, when the court rejected a unilateral decision to create tribunals, the president backed down and turned to Congress to create those. So hopefully we'll get something similar here.
Okay, I guess the optimum word here is hope. Professor Tsai, we have a long way to go in this case. Thank you for breaking it down for us, sir. We appreciate it.